So today's topic is about the legal framework, right? So legal framework is nothing but it is the framework of laws. Framework is nothing but collection, appropriate collection. Okay. That means if I can say that this particular BT text is a framework of 20 chapters, then definitely it makes sense. Why? Because collection of 20 chapters is what you see in this book. All the chapters are framed in this book like accordingly in order, and then all those chapters collection you can see in this particular book BT text. This is called the framework, right? In the same way we have legal framework. Now coming to the overview regarding the chapter legal framework, what we are going to see: sources of legal authority. That means who has the authority to frame or make laws. What are the source? What is the source from where the authority can be derived, right? For making laws, or how the laws can be framed. Then we'll see different like we'll see the employment law, which is nothing but the labor laws. Very important to be known, because in future you are going to become an employee in some company, whereby you would always want some protection for you against any exploitation. Then termination in what cases, and implication for the employer. That means if employer does wrongful dismissal or unfair dismissal, then what is the implication on the employer. Then comes health and safety law, very important, with respect to working in some place. So if you work in an organization or a company, you definitely want a very healthy environment and safe environment to work. What are the employer's duties towards health and safety? What is the employee's duties? See, it's not the employer who has to provide you best facilities. It is you who should also be very cautious while doing or performing your tasks. Then data protection and security. Data should be protected, it's a known fact. And security, what related security you can do with respect to protection of data. Principles of data protection, rights of data subjects. Data subject is nothing but whose data you want to uh, like maintain or store with you or keep with you, and then what are their rights. For example, if someone is taking my data, so I am the data subject for them. My rights are my data shouldn't be misused, right? Then data security, I will only give my data to someone whom I trust, and where I understand that my data is secured with them. No one misuses my data. Data can be anything: your profile, your number, your contact, your address, etc. Then contract law and consumer protection. So we'll see what is the contract law and sale of goods and services, right? So let's go ahead into the chapter sources of legal authority. So I told you from where the laws are made. The sources are nothing but in India and in UK. They run like parliamentary government we have, right? We have a parliament at the central level, whereby our representatives, like are the ones who are in the parliament. They represent us. We vote for them being our representatives, and many of the drafts are prepared in the parliament. Debates and discussions happen in see, India is a bicameral legislature. That means we have two houses: Lok Sabha, Rajya Sabha. UK also, they have like upper house, lower house would be there, House of Commons or whatever, House of Lords. I don't know, I don't have an idea about UK's system, but they may also have two houses, may have, and their debates and discussion happen. Lok Sabha, which is the lower house, has all the members who are representatives of the people of India. Rajya Sabha has the members who are nominated or vote or the ones who are selected by the Lok Sabha members. The people who come from various backgrounds, who have done something good for the society in various areas, they come in the Rajya Sabha. Some Anglo Indians have to be appointed. All those rules are there. See, that comes under constitution law. So they debate, discussion happen. Then whatever the draft, on which the debate and discussion happens becomes law when the president signs it, right? President is the head of our nation. So we have a parliamentary legislation which makes laws. The implementation is done by the judiciary, but the laws are framed and made by the parliament, and then government's rules and regulations. But government makes right for everything. Debate and discussion shouldn't happen in the parliament. Some things, some ordinances, some orders, some regulations are made by the government. For rules, like generally what is good for the society is seen, right? Then treaties or agreements happen between two nations, and hence both the nations, the treaty binds both the nations, and both the nations have to follow the treaty or the laws what is made, right? So country A and country B, so these two have made laws, made some treaty or some agreement between each other, and the treaty or agreement binds these two countries and they have to follow. That becomes law. Official regulations, so what from the offices of the government, some rules are made. International bodies also make, like UNO, WTO, they make rules, right? International Labour Organization, ILO, etc. Human rights. So key legislation for business organizations. See, the businesses which are existing in the environment wants employees, okay, to run their tasks efficiently, because you already know that organization is a social arrangement whereby they work for achieving something, some goals they want to achieve, and for that they require resources. So human resources or employees, so employment law is very important. Health and safety, because these people work in an environment and that should be very healthy and secured one. Then data of these people and also the customers' data is with the company, so that should be protected. And also the company is nothing but a business organization whereby they sell goods or they make contracts with their customers, okay? So sale of goods, okay? So these are the laws or acts which we are going to learn. Comes the first one, which is the employment law. So here the motive or the intent of making the employment law is protection of employees. Very well known fact. So the common sense prevails. This is the one law which has been framed, made for protecting the rights or the the employees' rights, and the employee shouldn't be exploited in any ways. Okay, so this law has been made. So employment laws aims to protect the rights or interest of employees. Generally employment laws tend to cover the following areas. First, recruitment. Recruitment is nothing but hiring. In particular, to ensure employers do not discriminate against particular groups. See, the recruitment shouldn't be happening on the basis of any discrimination. The recruitment shouldn't be happening by the managers who recruit or by the HRs, human resource managers who recruit the employees into the company, by giving them some special preference, based on some background, some caste, some religion, some culture, some custom, tradition, sex, etc. So no discrimination. Whoever is eligible, whoever is capable, whoever is competent enough, who has the skills, who is deserving, should be hired. Then minimum pay as per the government's norms or legislation should be ensured the employee should get, and there shouldn't be any kind of exploitation in this case. Parental rights, understood fact. When people, when someone is working in a company, they may be married, okay, people, and then during any point of time in their life, they may become parents. So either father or mother. So to mothers, maternity leave should be given. For fathers, paternity leave should be given. Maternity leave is what is very much followed better because it is for a longer duration, because the mother has to take care of the child or baby. Paternity leave is during the hospitalization days and etc. Like some, like the organizations cannot be very rigid when it comes to the male employees. They have to give them some opportunity to take care of their child at times when required, to ensure that employees are able to provide care for their children. Otherwise, they will be very much stressed and they may be not giving their 100%, because to give you 100% at your workplace, you should be completely devoted towards your work. You shouldn't be having any kind of stress in your mind, right? Very good working conditions should be given, like health and safety should be maximum, like should be considered fact, and maximum hours of work. So if there's overtime, they should be paid for that. Holidays when required, genuinely when the holidays are required, they have to be given. Okay, discrimination shouldn't be there in any cases. I already explained you. Bullying and harassment should not happen. See, when you work in an organization, ethics is what every organization should have in them, and some code of conduct is also there. So managers cannot treat their subordinates without respect. They should treat the employees with respect. See, managers don't own the employees, right? They are the ones who just have to get the things done in a very cordial or in a very proper way from the employees, in the sense not in a coercive way. Discipline and grievance procedures to ensure that employees are only dismissed if the employer has a valid reason for dismissing them, or in case of redundancy. That means if the employee himself or herself is not coming to the company for work, they don't want to do the work right now. So what is the reason for to retain them? So they may be dismissed. Redundancy provisions requiring the employees to be compensated in case of redundancy. So till the time they don't officially resign, they have to be paid for that. Termination of employment. When terminating an individual's employment, businesses need to ensure that they do this in accordance with law. There shouldn't be unfair dismissal. There shouldn't be wrongful dismissal. We'll discuss about it. If they see, the dismissal should be as per the law. If it is not as per law, then that may be that may be a failure from the organization's part to comply with some relevant laws. Okay, and the business will be found guilty for that. That means it will be breach of law. Okay, or they will be penalized for that. So wrongful dismissal and unfair dismissal, let's look into this. Wrongful dismissal, where an employee is dismissed and the employer has breached the terms set out in the employee's contract. That means employer and employee, I'll put it as small e, may have a contract with each other. Okay, I'll put it ER and I'll put EM for employee employer. As per the contract, there may be many terms and conditions, right? If the things are very clearly mentioned in the contract, and if employee has done some conduct of that kind or some activity of such kind which is breaching the contract, then that's okay. If employee hasn't done anything as per the contract, and again if the employer is removing the employee without any not with a valid reason, it's a wrongful dismissal. So when an employee is dismissed and the employer has breached the terms set out in the contract, that means the breach of contract can only happen if the things mentioned in the contract are something which is not followed by the employee. Okay, then employer and employee has a contract between them. Some conditions are mentioned in the contract. If the employee does not follow those conditions, employee can be removed. But even though the employee is following and still the employer removes the employee, okay, then it is wrongful dismissal, because that is the breach of contract. Okay, employee is following everything as per the contract, but still employer is removing the employee. That is wrongful dismissal. So an example would be failure to give the employee their contractual period of notice. So everything is fair from the employee side, but still employer removes the employee due to some grudge or some any other reason. Then that's a wrongful dismissal. Unfair dismissal, where employee has been dismissed for an arbitrary reason. The onus is on employer to prove that it was a fair dismissal. That means Unknown reasons, like for any other reason the employee has been removed, and employer has to prove that it was a fair dismissal, right? Implications for the employer. Just a second. Okay. Implications for the employer. Some employers claim that employment laws are overly generous. See what employers say, that whatever the labor laws are made are, very much supporting the labor or the employees. They are kind of not very generous towards the laborers and add to the cost of the business while also discouraging them to take on more staff. Other employers believe that the laws are fair and that it is important that their employees are treated well. Some are complaining, some are supporting. Employers may need to employ human resource experts. So you understood what is the difference between these two? Please tell me. Arbitrary reason can be anything like on basis of race on basis of sex, on basis of color, on basis of religion. I can say all these things. That means these are the reasons for which someone can be removed, right? This is against the terms and conditions. Like employer says that employee is not following certain conditions what employer has mentioned in the contract, so he's removing. So unfair is even not good thing, right? So this is what employers may need to employ human resource experts to ensure they do not unwittingly breach employment laws. So the HR team sees that the company should not, breach employment laws. So they are the ones who take care of the human resources, a separate department. Failure to comply with employment law could lead to the employee taking action against the employer. Yes, they can go to labor court or tribunal, labor tribunal, whatever. In the UK, employees may take an employer to an employment tribunal, which is an independent body. See, when employee thinks that they have been dismissed unfairly or wrongfully, they can, drag the company or organization to the tribunal because they have the right to, they have the right for justice. Okay. And this particular tribunal is an independent body that aims to resolve disputes, employment related disputes. An employment tribunal will listen to the employee's complaint, and if they agree that the complaint is valid, they will require the employer to do one of the following: pay compensation, improve working conditions, reinstate the employee if appropriate. Alternatively, employers may take employees to the court, although the cost of this may be prohibitive. Yeah, so failure to comply with employment law may also give the organization a bad reputation. Okay. See, they can take the employers to court, but they can also settle the case with the employee, with the employer, or employer can, listen to the employee and they can mutually settle it without, going to court and unnecessarily creating some cost. There's a real life example. So in Jan 2020, TV presenter Samira Ahmed won a gender discrimination case against the British Broadcasting Corporation, BBC, at an employment tribunal. That means she has been, some discrimination happened with her related to gender because she's a woman. She claimed that the work she performed as a presenter of the BBC's News Watch program was of equal value to work performed by male presenter, but she was paid less, it seems. So Jeremy Vine, who presented Points of View, yet Mr. Vine was paid almost 7 times the salary that Ms. Ahmed received. Ms. Ahmed claimed £700,000 in back pay. My God, and she won even. Good. So, these kind of things gives confidence to employees. Then health and safety law. Importance of maintaining health and safety at work is very important, paramount. An employer has legal obligations under domestic laws. Accidents and illness cost the employer money. Yes. Company's reputation in the marketplace and society may suffer. Yes. See, their reputation may be, it will hurt the employer's reputation if they don't provide proper safety and health. They don't maintain proper hygiene or health and safety standards. The major legislation in the UK covers a number of acts of parliament. EU law is important in member states. The most important piece of legislation in this area in the UK is the Health and Safety at Work Act 1974. So this is the act which has been passed and as per which all the employers should maintain the health and safety laws. Give proper conditions, working conditions to their employee, no compromise in that. Remember that UK law will not feature in the exam, but you do need to be aware of health and safety best practices. So employers' duties towards maintaining health and safety towards their employee, the senior manager must be specified as responsible for ensuring that problems are solved and rules observed. All work practices must be safe. Yes. Work environment must be safe and healthy. All plant and equipment must be maintained to the necessary standard. Yes, there shouldn't be any kind of, accident which should be happening, or like maintenance and servicing all should be done regularly. Information, instruction, training and supervision. So all the information to the employees, proper instructions, training and supervision should encourage safe working practices. Employers must provide training and information to all staff. The safety policy should be clearly communicated to all staff, of course, guidelines that how they should be using the equipments, how they should be, maintaining proper standards. Employers must carry out risk assessments. They should always study what kind of risk the organization is exposed to or the employees are exposed to. Generally in writing of all work hazards, assessment should be continuous, yes, and monitoring should be there. They must assess the risk to anyone else affected by their work activities. Yeah, they should be telling that what kind of risk the employees have towards what kind of work they are performing, right? Different works have different kind of risks involved. They must share hazard and risk information with other employers, including those on adjoining premises. Yeah, so they may be having some neighbor one more company may be a neighbor of this organization. Let's say someone is working in organization and organization B is a neighbor. So what dangers they can have from A or B or A can have from B should be disclosed to each other. Other site occupiers and all subcontractors coming into the premise should also be given some guidelines related to what risks they are exposed to. They must introduce controls to reduce risks. They should revise safety policies in light of the above or initiate safety policies if none were in place previously. They must identify employees who are especially at risk. Like, some tasks are such which are very risky. So employees should be, who are at the utmost risk, like in the mining job in mines or some kind of job in lab. Okay, so lab testing and all, they use some chemicals and also they should be very much cautioned. They must employ competent safety and health advisors who would guide. The safety representative regulations provide that a safety representative must be appointed by the recognized trade union and for safety committees to be set up at the request of employees. So a company should have a safety committee like audit committee, remuneration committee, and there should be some experts in that safety committee who should be taking care of the safety measures in the company, right? So these kind of things increase the cost to the employer, but see, in developed nations this is a norm. These are all there. So safety representatives are entitled to paid time off work to carry out their duties. Yeah, they should be paid because they are devoting their time. So employee duties, it's not only the duty of the employer. So we have seen till K, it's a duty of employee also to maintain certain standards, certain caution. They should be very much careful, not careless or caution. Take reasonable care of themselves and others. Allow employee to carry out their duties. That means they shouldn't be like interrupting employers in carrying out their duties, or shouldn't be kind of any hurdle or any kind of disturbance from their side or an interruption from their side when employer is reinforcing the safety rules. Not interfere intentionally or recklessly with any machinery equipment. Should not be in a playful mode with all these things. Inform the employer of any situation which may be a danger and use all equipment properly. Okay. There's a real life example. So Cemex UK Operations Limited was fined £1 million in 2019 after an accident in which a worker was killed at a site in Scotland. So the fines are not that less, right? It's a very, very harsh fine on them. See, a person has lost their life despite of all the regulations and compliances what the company should fulfill. The conveyor on which the employee was performing repairs unexpectedly activated and the employee was partly crushed by the conveyor's centering machine. Very dangerous, very not a good thing which has happened. UK's health and safety executive concluded that Cemex should have made sure the centering machine was isolated before any repair was carried out. A lack of adequate health and safety compliance had led to a tragedy that could have been easily prevented. Yes, they were careless. They should be careful. Health and safety, this activity should be done by you. Some activities why I give you purposefully as homework, because these are very, very general ones, can be performed by any student. So we are into the last and final topic of the session. More two topics are there, fourth and fifth. Let's wind up this one. Data protection and safety. Information about individuals who are the data subjects should be stored on computer files and processed by computer that could be misused. So whatever the data is stored in the system can be misused, yeah, right? Someone can extract the data and use it. May have some kind of like vested interest, or they want to take advantage of the data. They want to sell the data to some organization. Anything can happen. The internet, social media, and big data technologies. Big data is nothing but the data which, you know, like Facebook, Snapchat, Instagram. Now previously the data was only confined to the work. Now the data is, you know, the lot of data is there now. So this is called big data, whereby not only the business related data, transaction data, but also social media data. So big data is something like combination of all the data. So internet, social media, and big data technologies mean that increasingly large amount of personal data are available and could potentially harm an individual. In 2018, the EU issued the General Data Protection Regulation, which applies to all EU member states, right? So all the EU states are under the purview of this particular regulation, that is General Data Protection Regulation. So whatever the general data of the people, which is like, you know, easily transmitting through the social media and all, should be protected. Okay, some regulation has been passed for that, which applies to all the EU member states. The UK issued an updated Data Protection Act to bring its own laws into compliance with GDPR. And you are not required to know any particular law in detail, but just to understand the principles of data protection and security. Data subject is someone, is a person, right? Who can be identified directly or indirectly from data held. So here we see a particular example. In 2018, the Royal Dutch Lawn Tennis Association sold personal data about its members without their consent to two of its sponsors. They may have some work with the data, right? The data included names, gender, and addresses. The sponsors contacted some of the members by post or telephone to make them some tennis related offers. Yeah, some advertisement, something like that. The association was fined this much by the Dutch Data Protection Authority for breach of GDPR. So these kind of things are also something which should not happen. Outline some of the potential danger. This also can be done. So I'm giving very simple tasks to perform. Yeah, some complicated task would be there, which we will be doing collectively. Are you okay with this to do as a homework? Yes, Tanya, please tell me. They're asking some potential dangers that data subjects, that means the ones whose data can be extracted, face when organizations keep personal information about them. So what are the dangers? The data can be leaked. The data may not be in secured hands. Data can be sold. So you can write certain points, right? Now, data protection principles. The UK Data Protection Act includes 7 data protection principles with which data users must comply. Principle number 1, lawfulness, fairness, and transparency. Data can only be held if there are valid grounds to do so. Data can only be used fairly and with clarity. Openness and honesty in how the data is used from the start. So see, data should be like held on the valid grounds, that is lawful. Data should be, you know, used fairly and with clarity. And then transparency is openness and even very honestly. Purpose limitation. Data subjects, the ones whose data is required, must be made aware. So let's say there's some cricketer whose data is with some company. That's the cricketer is the data subject. So data subjects must be made aware of the purpose for recording the data. That means why their data is taken, why their data is recorded, collected. The purpose must be specified, explicit and legitimate, that whatever the data is taken is for only for legal purpose. Should data need to be used for a different purpose in future, then consent should be taken, right? Unless you will be sued. Data minimization. Data held must be adequate, relevant, not excessive data should be there with you. It creates confusion. Accuracy. It should be very accurate, not misleading, right? Not inaccurate. Storage limitation. That means the data should be stored properly. and retention policy should be there. Data that is not needed must be deleted, not of any use. Integrity and confidentiality. Yeah, don't disclose the data to anyone else. Accountability. If anything happened to data, you are responsible. Okay, you are answerable. Then rights of data subjects. For any time the data is required by any other source, any subject's personal data. Let's say a cricketer's data, some company is asking. So whatever data you have, whatever you want to do with the data, you should be doing only by informing to the data subject. They have the right to be informed. Access, they should always get the access of data. Any kind of rectification required, they can ask to do. They can ask the data to be removed from you if you're processing it. Okay, when they kind of understand that it's not in safe hands. If they want you not to process their data, they can ask you. Data portability, data subjects can request to send the data held about them so they can reuse it in a different service. They can object anything related to data. Automated decision making and profiling. That means other data protection rights are granted to data subjects where data held about them is used to make automated decisions about them. So wherever some decision has to be made automatically by taking into consideration their profile, etc. For example, the decisions are made by bank computer systems as to whether or not to lend money to an individual. The uses of data in this way is limited and the individual must be given information about the processing. Okay, see, you get a mail like you are eligible to get a loan, etc. So you can ask the banker to not sell such mails because unnecessarily you're getting all these mails which is disturbing you, right? But this is happening. But you have the right to stop that. Data security. The key risks affecting data are human error, means that incorrect information is stored about individuals due to human error. Point number 1. Technical malfunction. Just a second, I'll shift 2 minutes. Just a second, I'm shifting. Yeah. So technical malfunction. See, some malfunction related to data, deliberate malicious action, someone using the data for some other purpose. Hacking means unauthorized access to data either from within the organization or from outside via internet. Using internet brings numerous security dangers like viruses. So malicious programs that are designed to disrupt the systems, they are often spread via mail. So you should not like open such mails, phishing mails, etc. Deliberate damage caused by disaffected employees. Someone who is not affected can also do this with some grudge towards other employees. Damage caused by hackers, downloading of inaccurate information or virus hidden software. Internal information may be intercepted, but this can be avoided by encryption, keeping some codes. Communication link could break down. Data storage electronically is at risk of security breach. A particular risk is information regarding the business standing and competitive advantage. Personal and private information is at risk. Information regarding the business securities can be at risk. Information integral to the outcome of deadlines, some tender they're going to float or something, can be at risk. And when data is transmitted over a network or telecommunications link, there are numerous security dangers. Corruption such as viruses on a single computer can spread through the network to all of the organization's computers. Disaffected employees have much greater potential to a deliberate damage, yes, to valuable corporate data or systems, because the network could give them access to parts of system that they are not really authorized to use. That's what. So unauthorized use can also cause dangers to the organization. So controls relating to data security are described in the chapter on control and audit. We'll be seeing that afterwards. So what they are asking is, your managing director has asked you to recommend measures that your company, which is based in UK, could take to ensure compliance with data protection legislation. Suggest what measures should be taken. So how you can comply with all the data protection legislation. That means there is some act which has been passed related to data protection. So how the company can comply with that, what measures it should take. So this also is what I have explained you very properly. That means they should they must protect the data, they must keep the data in secured place, they should be seeing that human error is not there, they should be mentioning that authorized persons can only take the data. All these points you can write. Okay, separate department they can make for this. So you can just put on your words, Tanya, and you can just mention how that can happen in the organization, and you can send the answers to me tomorrow. When I'll start the class, I'll discuss the answers, because previously also what you have sent to me, I've checked it and I've reverted back. This time also whatever the answers you're writing, I'll be checking and reverting you back. Okay, now.
Okay, sir.
Yeah. So contract law and consumer protection. Just a second. So contract law is nothing but there are two parties, A and B. They form a contract with each other. The contract binds both the parties, and the breach of if any of the party is not following the terms and conditions of the contract, it will be termed as breach of contract. Okay, so what happens if A has agreed to construct an apartment for B. A is a builder and B is a consumer, and if A does not deliver it on time to B, is a breach of contract. So B can claim damages from A. So that right B has, right? And consumers, if they don't get the products what the company has promised to them, then they also have certain protection. They can approach the consumer forum or consumer court, and they can claim damages. Two areas of law that are relevant to the consumer are court law and laws relating to sale of goods. So contract law. So there are, see, this particular A and B, in this case also B was a consumer I can say, and A was the builder or seller. So here contract law has come into picture. Okay, because there was a contract between the builder and the customer, or the seller and the buyer. So contract law has come, and also Sale of Goods Act has also come, because this particular apartment building, whatever the A sells apartments to their customers, this apartment is nothing but inventory for A. Okay, so now you are required to be aware of the principles of such laws. First, contract law, which is based on English law, but most countries adopt similar principles. Yes. So when consumers buy goods from retail store or online, they are entering into a contract with the seller of goods, of course. So a contract must have three elements for it to be legally enforceable. First, consideration. Seller should quote some price for the goods what the seller is selling, and the customer should pay. There should be offer and acceptance. The offer should be given by the seller, and the customer should accept. The seller cannot sell the goods forcibly. And intention. There should be intention. That means they should have an intention to enter into the contract. Okay, and the seller should have the intention to sell the goods, or fulfill the terms and conditions in the contract, and the buyer should also have the intention to pay the money for that. Now, elements of contract. So a woman was walking down the high street where she saw a bedside table in the window of a furniture shop with a price of 30 pounds displayed. The woman went into the shop and told the owner she wanted to buy it. She paid for the table at the cash register, and the bedside table was delivered to her home the following day. Identify each of the three elements of the contract above. So you should identify this, right? What are the three elements? There should be a consideration, right? So she paid some money. So there's a furniture shop here, and woman saw some bedside table in the window of a furniture shop. So she paid the price for that, right? So consideration should be there. Something is charged by the seller and paid by the buyer. Whether there was an offer, yeah, the seller was offering the goods, and the consumer accepted. Intention. We'll see the activity 4. Yeah. Okay. So stores bedside table and consumers money. Telling the owner she wanted to buy the table was an offer, and the owner agreeing, yes, and there was a consent, right? Sale of goods and services. An important area of contract law is the law concerning the sale of goods. UK legislation also covers contracts where the supply of services is a major part of the contract. For example, contracts of repair where supply of goods may be incidental to the provision of service. So whatever the goods the company is selling to the customer, they have also contracted for services. See, sale of goods, supply of services. So what happens in UK is, it's not only the sale of goods but also supply of services. So an important area of contract law is law concerning the sale of goods. UK legislation also covers contracts where supply of services is the major part of contract. For example, if goods are sold, that's okay, but they are also making a contract of repair, okay, for the goods what they have supplied, so, or sold. So there is a provision of service as well. So imagine that you are about to enter into a contract for purpose of some goods. What might you be concerned about? So you may want some goods for some particular occasion or date. You may want the goods delivered for a particular occasion or date. Are the goods stolen? That is, the seller has the right to sell the goods. Does the seller has the rights to sell the goods? That means the title of the goods should be with the seller. Seller should having the clear title for goods. No one can sell the stolen goods, right? If seller has bought the goods, then only they can sell the goods. They have the title to do that. You would expect the goods to be of same type and quality as per the description or sample. Goods should be reasonable quality and suitable for their purpose. That means for the customer. UK Consumer Rights Act 2015 legislation covers these matters and a number of other important issues. When a customer enters into a contract for sale of goods, the following terms are implied, which means the consumer can assume the seller has complied with them. So seller's right to sell the goods, definitely they should have the legal title. Whatever has been described, the goods should have the description. Whatever is made, the goods should be of that of that particular description, and should have a proper quality. Okay, should be free from defects, right? These are the important points. So in India also, when you buy the electronic items from some showroom, they also offer you some services, right? We will give you some service apart from this sales of goods what we have done, and they charge separately for services, right? Okay. So Tanya, have you read this? Hello.
Yes, sir.
Yeah, so like you have any major queries or you want to ask some questions?
No, sir, I understood everything.
Yeah. So like what do you mean by this incidental? UK legislation also covers contracts where supply of service is a major part of contract. For example, uh, contracts of repair where supply of goods may be incidental to provision of service. What do you mean by this? So if you are selling goods in connection to that, you are also providing service. Understood?
Okay, okay, sir.
The thing of greater importance is supply of goods. Along with that, with connected to that, you are giving some service also, right? That's what. So done with this chapter, we will start the chapter number 4 tomorrow. The chapter number 4 is macroeconomic environment. Okay. Thank you.